Okay, I will call this committee of the Senate Judiciary to order. Secretary, will you please take the roll?
Present.
Senator Orenshaw, Senator Lang, Senator Wynn, Senator Hansen, Senator Krasner, Senator Ellison, Chair Scheibel.
Here, please mark Senator Wynn present when she arrives. I believe Senator Ellison is out today, excused. He's definitely excused. I just wasn't sure if he had made it in today. And today we only have one bill on our agenda. It is SB 346. As I am the sponsor of the bill, I will hand the gavel over to my esteemed co-chair, Vice Chair Flores, to open up this hearing.
And at this time, we'll open up the hearing on Senate Bill 346. Madam Chair, whenever you are ready.
Thank you, Vice Chair Flores, Senate Judiciary Committee. For the record, my name is Melanie Scheibel. I'm the State Senator for District 9 in Southwest Las Vegas. I'm very pleased to be joined by Catherine Nielsen this afternoon presenting SB 346, which makes some changes to promote supportive decision-making here in the state of Nevada. By way of background, this bill came to me through the Interim Judiciary Committee, but not through the committee. In one of the committee meetings, we heard about some people who had been involved in supportive decision-making and the need to expand and improve and strengthen our laws in supportive decision-making. And so I was very lucky to work with a group of stakeholders to whom this is personally incredibly important, and I'm proud to sponsor SB 346. You do have a conceptual amendment that is intended to further clarify the relationship between supportive decision-making agreements in our state and other states, and ensure that people who are moving across state borders are able to fully access these really helpful and really transformative agreements. And I'm going to turn it over to Ms. Nielsen, who is really the expert here and can explain the bill, and will both be available for questions.
Thank you all so much. Catherine Nielsen for the record. The biggest thing that we want to explain behind the bill is that guardianship is a legal proceeding that can remove civil rights and privileges of individuals by assigning control of his or her life or aspects of their life to someone else. And we want it to be very difficult for somebody to remove somebody else's rights. Guardianship should not be an easy thing for somebody to come by, and they should be able to exhaust all other options before guardianship should come about and be approved. So the measures behind this bill are working to enhance the current law that we have passed to support supported decision making, and we also wanted to clarify a few pieces within the bill as well. So in Section 1 of this bill, we have expanded supported decision-making to have the meaning that is described within NRS 162C, but we wanted to also ensure that Chapter 159 of NRS also enhances NRS 162C, and that at any time anybody is looking up Chapter 159 of the NRS, that they also see that there are alternatives to guardianship before they can take that measure into consideration. So within your conceptual amendment, as noted, there's one piece in here that we have asked to expand beyond the language that was originally submitted. As people are moving into the state of Nevada, we know that laws in other states do not necessarily equate to the laws that we have passed here. So when somebody is asking to move a guardianship from any other state into the state of Nevada, we've asked for them to take into consideration supported decision-making and alternatives before that guardianship is granted and moved over into our state. We've also made sure that if a guardianship is considered, that a licensed physician is ensuring that supported decision-making is not an option. And I know that that might be some point of contention, and we got some questions on that as well. We are not saying that a physician needs to sign off on supported decision-making. We are saying that if a guardianship is granted, then a physician is stating supported decision-making is not an option or does not work for the individual. So it's making guardianship harder for individuals to grant. Sorry, there's like a Beautiful. And the other pieces that are listed within this bill as well ask that evidence be shown why supported decision-making was considered and an explanation as to why supported decision-making is not a reasonable alternative to guardianship. So we're really asking them to explain why is supported decision-making not good enough? Because most people are capable of utilizing the skills within supported decision-making. Another portion of this bill is that supported decision-making has not been considered for the protected person in this state or other states. We know that supported decision-making is not a law in all other states. And so we're asking that if somebody is asking to transfer a guardianship here, that they go through the same process of proving why supported decision-making is not a good alternative. And I believe that that is to the point that we are at in this bill. We are also asking that the court provide education about alternatives to guardianships, including without limitation, a supported decision-making agreement. We do note that some courts do currently provide this information, but we wanted to make sure that the law requires that they do so before a guardianship is passed. And I believe that we are.
I'll just add a few more comments. I want to clarify that we have different kinds of guardianship here in the state of Nevada. I think a lot of us think of guardianship as being for minors, when you're taking over, or when a person's taking over guardianship of a child, a foster child, something like that. But we also have guardianship in the adult context. And what is both interesting and can be troubling about adult guardianship is that it carries the same legal weight as guardianship of a child. And so I think we can all appreciate that the kinds of rights and decisions that you would want a guardian to be making for a child, you don't necessarily want for an adult. Because if I'm becoming the guardian of an 8 or a 9-year-old, it makes sense that I'm in charge of all of their medical decisions. It makes sense that I'm in charge of their educational decisions. It makes sense that, you know, they can't sign a contract by themselves to lease a new car or, you know, lease a new apartment. When it comes to an adult, that's where it becomes different and more difficult, because for an adult who, for whatever reason, isn't capable of making their own decisions, a guardianship grants the guardian all of those same rights that we just described for children. So plenty of adults fall into a category in between where we call them persons, you know, in need of protection. I think persons in need of protection. Persons in need of protection because they have some kind of cognitive disability, they have some kind of developmental disability that makes them presents challenges to them for making decisions like educational decisions, making decisions like purchasing a home or leasing a car. But it doesn't mean that they're entirely incapable of making those decisions like an 8-year-old child would be. Now, certainly, there could be cases, if we think of perhaps, you know, very elderly people who are suffering from dementia, it might be appropriate to have a full legal guardianship of that person to ensure that they're not, you know, making irresponsible decisions with their finances, that they're not making irresponsible decisions with their health care. But for so many people who are in between, who are adults in their 30s and 40s, who require some extra assistance to understand a legal contract, to make a decision about, you know, going back to school, taking out tens of thousands of dollars of loans for higher education, a guardianship might not be appropriate because we might not want to give another adult that blanket authority to make decisions on behalf of another person. And so that's where supportive decision-making comes into play. That's where the person who is in need of protection pursuant to the law, and the person, I think it's fair to say, who would otherwise be their guardian, becomes their partner in supportive decision-making. And here in the state of Nevada, the courts utilize uniform forms, I believe, to develop those supportive decision-making agreements that specify, you know, how decisions are going to be made collaboratively between those two people, the adult who is not deemed to be a person in need of protection, as well as the person in need of protection, so that the court has some guidance and they have some direction when it comes to, you know, a question. When that person in their 30s wants to, you know, has to make a serious medical decision, whether or not they're going to undergo some kind of surgery. And the court now has an option between simply, okay, person in need of protection, you have to make the decision by yourself, and hey, person who is deemed a legal guardian, you're going to make this decision for them. This actually provides a legally recognized middle ground for the court to say, okay, what we're going to do is we're going to go through the steps of your supportive decision-making agreement. According to your supportive decision-making agreement, and each one it's on a uniform structure, but each one has its own section. So it might say, according to your agreement, you are supposed to evaluate these different considerations. According to your agreement, you've agreed to have, this type of discussion before entering a decision. According to your agreement, both of you, the person in need of protection as well as the supportive decision maker, both have to agree. And if you can't come to an agreement, you have to keep talking it out until you do. So that way the court is empowered to say that this decision has been made in accordance with the law and ensures that the person who is in need of protection still accesses the benefits of having a guardian without having the drawbacks of losing their own civil rights and their own decision-making abilities. And so none of the supportive decision-making process or language would apply to children. That is a different type of guardianship. And I think that that's just an important, it's important to recognize, important to understand when talking about SB 346 and the proposed changes. And I think with that, we're open to any questions. That's all I wanted to add to the record.
Thank you both for the presentation. We'll start off with Senator Nguyen, please.
Thank you. I just remember during my first session in the Assembly in 2019, when this law and this act was being presented, I was like, I can't believe we haven't had this kind of supported decision-making in our state. So I'm glad to see that it is doing well and it is thriving, and I'm grateful to our chair for presenting any updates and making sure that we're keeping an eye on it. So not really any question, just more of a comment. So thank you, and I'm glad to see that this is working.
Next, we'll go to Senator Lang.
Thank you, and thank you for clarifying that, because that's what we were talking about. Is this adults or kids? And so I really appreciate that, because I wasn't here in 2019 when the law came into effect. I'm a guardian of a youth, and so I'm familiar with that process. And I know that we have to go to the court, give a report to the court once a year about the guardianship and what's going on, answer certain questions. And then we just had this spring a meeting with the judge where our grandson talked to the judge. Is there in place something like that in adult guardianship where there would be a check once a year, or they would see the judge just to make sure everything's going okay?
Yes, Vice Chair Flores, to you, Senator Ling. So there is, and we've actually expanded that a little bit as well, that I'm sorry, Catherine Nielsen for the record, I apologize. We've expanded that as well as every year they're required to come back at a status hearing for the guardianship, and we've asked them to also include in that status hearing the status of their supported decision-making skills. It's because we know that people can build on those, and we know that those can grow over time, so we want to make sure that if a guardianship is continued, that it's in the best interest of the individual.
Senator Krasner, please.
Thank you, Vice Chair. Thank you for bringing this bill. I was there in the 2019 session when we had this hearing as well, and I am so happy to see that there's another option. This supported decision-making agreement is such a great idea. You know, we've seen in the news also about people that get into a guardianship agreement and they really want out, and somebody's kind of abusing them by like saying, I have control over you. Or there was even a famous female celebrity where that happened. So I love that. The only question I have is these guardianships, and not the supportive decision making, but since we're also talking about guardianships, how does somebody get out of one? Let's say they are mentally incapacitated temporarily, but then they make a recovery, a full recovery, and they want to get out of the guardianship. how I've heard that is very, very difficult. It's almost a life sentence once you're in one of these guardianships. So thoughts on making it a little bit easier to get out of that if you can prove that you've made a recovery, or and what are your thoughts? Thank you.
Melanie Scheibel for the record. You are correct, it is very difficult to dissolve a guardianship once it's been established for an adult. I do think there's actually something in this bill that will help, and it is in the conceptual amendment, and Ms. Nielsen touched on it in her answer to Senator Lang's question. I think it's in section, oh no, it's not in section 7. It is in section 7. In section 7, in subsection 5, it does two things. Well, it does one thing in that section. In other sections of the bills, it does a different thing. But the thing that it does in this section is require that a person who is going to be placed under guardianship, that a supported decision-making agreement has been considered for them, and that includes people who come from another state. And so, for example, if somebody was in a guardianship in Kansas and their guardian chose to move them here to Nevada, if we pass SB 346, instead of just automatically recognizing that guardianship, the guardian and the protected person would have to come into court and explain to a Nevada judge why they're not using supported decision-making instead. So that's one place for the judge to, have eyes on somebody who's already under guardianship. If they're moving here and a judge here determines they could have done supported decision-making instead, they'll have to do that. And then the other thing that Ms. Nielsen mentioned is at that annual kind of check-in status conference, we are now requiring judges to evaluate the availability of a supported decision-making agreement. So it should be that if a protected person can't, wants to enter a supported decision-making agreement instead, the obligation is not on them to bring it up. The judge should be asking during that hearing at some point, okay, everybody, and where are we on a supported decision-making agreement? Is it possible at this point in time? Could we revisit that?
Just a quick comment, Chair. Thank
Please.
you. That's really wonderful. Because as you said, it does take away people's civil rights. So thank you so much.
Members, any additional questions? Seeing none, thank you both again for the presentation. I'd like to invite you to sit back in the gallery. And at this time, we'll invite those wishing to testify in support of Senate Bill 346 to please come forward in Carson City or Las Vegas. I do see somebody in Las Vegas. We'll start there, and then we'll move our way back down to Carson City. Good afternoon. Welcome.
Good afternoon, Mr. Vice Chair, members of the committee. Stephen Cohn for the record, legislative liaison for the council, here this afternoon testifying individually. Just want to point out one thing, that there is no uniform form that's required. But in general, I would love to enter an agreement. There did come some challenges because of COVID, for example, that it required 2 adult witnesses, but in general, it's wonderful that, as the senator said during Q&A, that it's a way to protect civil rights and should be considered in every state. And I was trying to look at the national website, and it looks like it's in 15 states, including ours, and would love to see it in every state. Thank you, Mr. Vice Chair. I yield.
And thank you. I don't see anybody else in Las Vegas. We'll move down to Carson City, please.
Good afternoon, Senate Judiciary Committee. My name is Maximilian Lowe. I am, as a person with a disability who lives independently, I understand firsthand the importance of safeguarding a person's right to autonomy and self-determination. SB 346 is a critical step in strengthening protections for individuals under guardianship in Nevada, ensuring that those who need assistance can receive it without unnecessary restrictions. Through my experiences, I have seen friends under guardianship struggle with issues they are afraid to speak up about, whether it's concerns about their services, their rights, or even reporting a crime against them, simply because they do not know where to turn or fear of retaliation. No one should have to choose between their safety and their support system. I hope you support SB 346 as it provides a framework for the least restrictive option for individuals with disabilities without the need of having to make major life decisions or managing daily activities. Most importantly, it promotes advocacy and supportive decision-making, empowering individuals to report and assist their rights without fear of losing their services or supports. By passing SB 346, we are upholding the dignity, independence, and rights of people with disabilities in Nevada. Thank you.
And thank you for joining us. Good afternoon, welcome.
My name is Marquez. In June.
Hi, my name is Alyssa Marquez, and I have Down syndrome.
Becky.
And I'm Becky. I'm going to be assisting her.
I am.
It's okay. What are you doing?
Sorry.
She's just a little nervous. Remember, you make your own decisions.
Decision making.
She has her own supported decision-making agreement.
Doctor.
Sometimes when she goes to the doctor, they don't think you make
Decisions.
Sometimes when she goes to the doctor, they don't think that she can make a decision.
But can.
But she can.
My mom.
Her mom?
Help.
Her mom is the one that helps her.
The staff is Catherine Nielsen, Becky Ortiz, and Marcel Vivas.
And at her job, she gets help from the staff, which is Catherine Nielsen, Becky Ortiz, myself, and Marisol Rivas. You make decisions like everyone else.
Someone else.
She can make decisions like everyone else.
And help the families. And Jordan and Ashlyn.
Sometimes she just needs a little help from her family and her friends, Jordan and Ashlyn.
Help.
Please add.
Just ask. Decision making.
Please add supported decision making
Guardianship.
to the guardianship law.
Thank you.
Thank you both for joining us. And for the record, for clarity, it was Becky Ortiz? Yes. Perfect. Thank you. Just wanted to clarify. Appreciate you joining us today. Good afternoon. Welcome.
Good afternoon, Vice Chair Flores and committee members. My name is Ellen Marquez. I am here today making comments on my own behalf and not on behalf of my employer. I am a proud parent of a young adult with Down syndrome. For too long, guardianship has been the default option for individuals who need assistance with decision making. While guardianship has its place, it can also strip individuals of their rights. NRS 162C.200, the Supportive Decision-Making Law, SDM, offers a less restrictive alternative, one that empowers individuals with disabilities and older adults to make their own decisions with the help of trusted supporters. However, many professionals do not recognize or they question SDM's validity, creating unnecessary barriers. By adding SDM to Nevada's guardianship law, we can ensure it is a recognized and respected option, preventing individuals from being forced into unnecessary guardianships and aligns with our state's commitment to self-determination. It allows individuals to retain their rights while receiving support from family, friends, or professionals to make informed choices about their health, finances, and daily life. In reality, we all use SDM in our daily lives. If you were considering purchasing a new car, you might ask someone who owns the same model about their experience, the positives and the drawbacks, before making your decision. This is SDM in action. If we all rely on guidance from trusted sources, why shouldn't individuals with disabilities and older adults have the same opportunity? I urge you to support SB 346, which adds SDM to Nevada's guardianship law to create a more balanced, person-centered system that upholds the rights of all Nevadans. Thank you.
And thank you for joining us. Good afternoon, welcome. And I believe if you could just turn on your mic, it looks like a sticker.
Does look like a sticker. Yeah. For the record, I'm Larry Daly. The Americans with Disability Act already says the public entities should take appropriate steps to ensure that communications with applicants, participants, and members of the public and companions with disabilities are as effective with, as communications with others. It also says that people with disabilities are to be given the same access as others. And if it's not, it's discrimination. So the bar should be very high indeed to put somebody in a more restrictive environment. In some ways, I'm kind of flummoxed that we even have to be here. The law is there. But I gotta say, as a parent of someone with disabilities, doesn't matter. Do you realize that NRS 435-4301B says that the Director of Aging and Disability Services shall provide continuity of services to all people with disabilities in the state? She'll pass regulations for that. My daughter hasn't had those services in 2 years. So I guess I'm here to issue a cautionary tale. I applaud the effort that the Senator and Ms. Nielsen and everybody else who's worked so hard on this has done. But words are words. They need accountability. They need actions. So the NRS there is no or else. Or else the person's fired, or else there'll be an investigation. Those words are there. There's no tooth to that law. What are we going to do to make sure that these people coming in who may be getting their new rights, that they actually get them and it doesn't sneak through? Okay? The other caution I would issue is this is about the least restrictive environment, right? If people can, they should. I've been in meetings with government employees where they tell my daughter, we can't give you the services that you want, but if you take this more restrictive environment that's more like an institution, we'll give them to you today. Now, we're not coercing you. We're not telling you to do that, but you can have services today, or else it'll be 2 years. So I guess I don't know how in a biennial legislature we can build a system where our laws are based on empathy, reality, and complexity, because the shortness of the session seems to limit those things. But people are being hurt. I think people are dying. And I think in the political climate we're about to go through, it's going to get worse. So certainly I ask that you vote for the legislation that we have to have that. We shouldn't even have to say it. Least restrictive is good. But as you consider these laws and regulations, put an or else in there. And here's how we'll monitor this. The agency doesn't monitor itself. We're going to put some teeth to it. There are people who are wonderful in ways that we cannot imagine. But they're different. What makes them different? What makes us different? Makes us beautiful. Please pass this law and do other work to help all the beauty shine. Thank you.
And thank you for joining us. Is there anybody else wishing to testify in support of Senate Bill 346, Carson City or Las Vegas? BPS, can we go to the phone lines for testimony and support, please?
Thank you, Vice Chair. If you would like to testify in support of SB 346, please press star 9 to take your place in the queue.
Good afternoon. My name is Anna Marie Binder individually, and I'm calling to express support for SB 346 for continuing to empower individuals with intellectual and developmental disabilities to direct their own lives to the fullest extent possible, promote the best practices of person-centered planning, informed choice, and self-determination. Thank you.
Thank you. Next caller in support, please.
Good day, Chair and the members of the committee. We want to thank, my name is Dora Martinez and I represent the Nevada Disability Peer Action Coalition. We want to thank the sponsors of the bill, and you know that saying, nothing about us without us. It means nothing without our decision, and it's about us. So please, with that in mind, I hope you do support this bill, and thank you so much.
Thank you for joining us. Next caller in support, please.
There are no further callers to testify in support at this time.
Thank you. At this time, I'd like to invite those wishing to testify in opposition to Senate Bill 346. If you could please come forward, Carson City or Las Vegas. Seeing none, BPS, do we have anybody wishing to join us over the phone in opposition to Senate Bill 346?
Thank you. If you would like to testify in opposition to SB 346, please press star 9 now to take your place in the queue.
Barry Johnston, Las Vegas, BERRYJOHNSTON. I am here to say I'm in support of strengthening guardianship, but not the way this bill is written. There is one critical fix that needs to happen in this bill. Courts and government agencies must be required to follow the expert opinions of licensed physicians in guardianship cases. My family lived through a nightmare. My elderly mother was mentally in a mental health crisis from advanced dementia. Our doctor and brain center, some of the best dementia experts in the state, provided legal documentation saying we needed psychiatric help immediately. We told them we must restrict her visits to only psychiatric professionals. Instead of acting, the government sent well-meaning social workers who made her think we were trying to lock her away. We weren't. We were trying to get her on the medication that worked, but she wouldn't take because it made her urinate more. Even when we filed with the court, unelected bureaucrats with no medical training overruled our doctors. They stalled care, blocked treatment, and dragged the process out for months while my mother got worse. After speaking to Metro's behavioral health unit, they couldn't help because of the law. Sheriff, if may help, may want to get great tech, but critical forms like L2000 still aren't digitized, making it nearly impossible to act as during a mental health crisis when time matters most. His officers do not have the training to help elderly either. Kids out of the academy told me that they're the ones asking questions, spewing nonsense. As an awesome, kind officer, understood we were trying to help with my mom and had to stop him. I'm sure the people involved meant well, but their egos and lack of clinical understanding did more harm than good. We were trying to save my mom. The system fought us the entire way. That's why I urge you, add clear language to this bill mandating deference to doctors when psychiatric care is demanded. This isn't about control. It's about clarity, safety, and doing what's right. Doctors must lead. Bureaucrats must follow. That's how we protect families, restore dignity to a broken system. And that gentleman's right. The Department of Aging has absolutely no accountability. They do not care whatsoever. And I had to go to the buildings over by the airport and talk to the executive branch to get some help to figure out why the Department of Aging was failing so bad. I appreciate your time. Thank you.
And thank you for joining us. Next caller in opposition to Senate Bill 346.
There are no further callers to testify in opposition at this time.
Thank you. Lastly, those wishing to testify in the neutral position to Senate Bill 346, if you could please come forward, Carson City or Las Vegas. Good afternoon, welcome.
Good afternoon. Homa Sayar, H-O-M-A, last name S-A-Y-Y-A-R. I'm testifying in neutral because old habits die hard. I'm appearing in my personal capacity, but as a government employee, I'm very used to coming up in the educational capacity. I commend to your attention the testimony from 2019, especially the Assembly testimony for Assembly Bill 480, just amazing support. And I think that as legislators, you don't often get to hear the and then, what happened then. Supported decision making is robust in Nevada. It is thriving, and in part because of individuals with disabilities doing outreach and education, families doing outreach and education. I joke that I'm a recovering guardianship attorney because I'm not in that space right now, but I have been in guardianship for almost 20 years, and I served for 4 years on the Second Guardianship Commission. You may find that people say, oh, well, it's not necessary to memorialize something in law, but we also know that it is helpful to be able to point to references in other statutes. A lot of what is contained in this bill is actually pattern and practice in the courts right now through the Guardianship Commission's forms, which prompt the asks about least restrictive alternatives, but it is a lot more powerful to have it in NRS than a form that could be changed. And I also wanted to, there was a question about the ability to get out of a guardianship. Nevada is really the forefront of the nation in providing counsel, legal representation for every single person in an adult guardianship case through our legal aid organizations in the South, in the North, statewide. These people do amazing work. They connect with people. They go to their homes. They make sure that they know how they're doing. And when they have those annual reports, whether they still want a guardianship, whether they're still okay with how things are going on. And then we have the Guardianship Bill of Rights, which actually has a civil penalty for its violation. And those include the right to be heard about your wishes, the right to be where you want to be and do what you want to do. So I just thought I'd offer that educational context, because sometimes when supported decision making comes up, the conversation bleeds into guardianship, but it's a continuum of supports, and supported decision making is absolutely a least restrictive alternative. And the reason we originally brought the bill in 2019 was because we were finding that doctors and dentists and these individuals were not recognizing individuals with disabilities, right, like any of us have, to communicate and make our own decisions, given that they were essentially the victims of ableism. If I go into a doctor's appointment with a friend sitting with me, no one will question it. If I had Down syndrome and did that, suddenly a doctor might say, wait a minute, why are, do we need some legal protection? But the law as it exists protects those doctors relying on the agreement, and the bill makes sure that in guardianship it is being adequately examined. So I appreciate your time.
And before you leave, we do have a couple questions for you. We'll start off with Senator Orenshaw.
Good afternoon. Thank you for all your hard work on this issue, and thanks to Senator Pazina and Ms. Nielsen for presenting this bill today. A couple of quick questions with the Vice Chair's indulgence. The annual meeting with the proposed changes in the amended version of Senate Bill 346, do you think that this will facilitate if, let's say, someone's in a guardianship, they're a ward, and at that annual meeting they would like to transition to a supported living arrangement? Do you think this will facilitate that? And if that's a yes, do you foresee the current guardian then being part of that supported living arrangement, or do you think it would be a different person? Appreciate your expertise in this.
Homa Sayar, for the record, through the Vice Chair to you, Senator. So in current practice, the annual meeting is meant to check on a variety of, the performance of the guardian. There are two kinds of guardianship. There's guardianship of the person, which relates to medical decisions. There's guardianship of the estate, which relates to financial decisions. I think that the goal, as I understand it from the presentation and from speaking to the sponsors, is to make sure that supported decision-making specifically is called out as a recognized least restrictive alternative. We have a thing we call the school to guardianship pipeline, and that's where suddenly somebody is turning 18 or getting older, and it's a really large growing component of guardianship, where suddenly a school might say, come back with a guardianship order if you want to be a part of this meeting or that meeting. So we've got that kind of group there. And those individuals, when they're experiencing their annual meeting, if they haven't been exposed to supported decision making, it's a helpful circumstance to make sure that they're aware of NRS 162C. So 162C is part of the series of the power of attorney chapters, right? NRS 162A is the power of attorney. 162C relates to supported decision making. So I think, to answer your question, it allows like a spotlight to be shined on what is a really robust and important component of least restricted alternatives, and so that's beneficial. So I'd mentioned there's sort of our youth with disabilities, and then we've got our individuals who have been in guardianship a while. They are definitely the people that would be great to reach next, because we have had school districts really embrace supported decision making, Washoe County and those other school districts, but the people who have been in guardianship and coming back for these annual reviews, it's good to have that call out. The court might be aware of these options, but a lot of families are looking for that explicit, it's in chapter 159, it's not just something someone's telling me, oh look, it's over here. A lot of families are incredulous, and I think it's in part because of our culture of, an example was once given me that a parent of a child with disabilities who's been trying to get them services their whole childhood is very used to defending the idea that my child needs supports, my child needs help. So then when they're presented with least restrictive alternatives, they're scared, right? They're in the situation where they don't know if anyone's going to recognize it, they don't know if their loved one is going to be subject to exploitation, and so it's a way to kind of talk them down from, no, look, this is recognized by the law, let's do this, and if for some reason it doesn't work out or doesn't work out for all these choices, then we could even do a blended version. We have cases where they have supported decision making for their medical decisions, but then they have a guardianship of the estate to handle maybe more complex financials. So it really lets you choose your own adventure, and it's good to have the nod in chapter 159.
Thank you very much. I appreciate the explanation and your expertise on this issue. Thank you, Vice Chair, for the indulgence.
Thank you. Senator Krasner, please.
Thank you, Vice Chair. Thank you for your testimony today. So in some of what you said, my concern's not with the doctors and dentists. My concern is with the guardian themselves. And I'm sure there's some guardians who really do a great job and care about the person that they have a guardianship over. But what about the ones that don't? And I appreciate that now we're going to have the once-a-year status conference, but that's a great deal of power to have and to take away from someone, again, their civil rights, their decision-making skills, their decision-making abilities over their finances. Somebody works their whole life to save their money, and now they turn a certain age and somebody says, well, I think I can make better decisions than you, or you were sick for a period of time and you're still sick and I'm recommending you're on medication. And I mean, who's watching the guardians? It should be least restrictive. There should be a way to get off of it. People should have their civil rights reinstated. They're not criminals. They haven't committed a crime. That's just a concern. So if you can comment, thank you.
Absolutely. Homa Sayar for the record. Through the Vice Chair to you, Senator. As I mentioned before, I think Nevada's greatest defense against that power disparity for existing guardianships or people trying to get guardianships is the appointed legal counsel. Case is filed, or sometimes there are existing cases that get set for the annual report, and they look at the case and say, oh my goodness, this person hasn't had an attorney from Legal Aid Center of Southern Nevada or Nevada Legal Services or what have you appointed. They will appoint that person will look through the file, that person will make inquiries, that person will visit with the protected person and make sure that they're still okay or understand what's going on. There are also safeguards in NRS Chapter 200 that actually require counsel for the protected person within 20 days to report any indication of abuse, neglect, exploitation, isolation that they may hear from Adult Protective Services. So there are mechanisms outside of even the guardianship to make sure that that counsel knows if something untoward is happening or needs to be fixed. But to the point of, sort of the civil death penalty that guardianship is sometimes referred to as representing, through the iterative reforms from this body, the redefinition of incapacity was one of the biggest, most helpful things, because I used to joke when I was initially practicing guardianship that if I had a broken arm, someone could get a guardianship over me because I can't sign a check, right? It was so broad. But now we're at a point where we're talking about the ability to make and communicate decisions. But for the situation where you've got a guardian that's not behaving appropriately, there are ways to report. There's legal counsel. It's being examined. For ones where a new guardianship is coming into place as a control, then that is also strictly scrutinized. Now, for the situation where someone's going from a guardianship to a supported decision-making agreement, the choice of who the supporter is or supporters are is entirely up to the individual. So if they're exiting like a guardianship and they don't want that person to be their supporter, that's entirely up to them. It doesn't like flow that I didn't get a guardianship, so now I get to be your supporter. No, it's 100% in the individual's decision to decide who they want to support them and the scope of that support. I think you heard testimony too about there's not a prescribed form. There are a lot of forms out there, but what we've been trying to avoid in guardianship reform is the checkbox, right? This habit of, oh, the physician, if I check this box, you'll get help. Because a lot of people, when they get certified as having incapacity, it's because their medical professional thinks it's unlocking resources. Oh, I can go help you apply for Medicaid or this or that, but this forces the courts and the parties involved, including legal counsel, to really say, is that what we need, or can we get you other supports? We can help you apply for Medicaid, or we can do those things. So I would say that the protections are robust, and that there is absolutely a way to exit guardianship. I do know last session there was a bill seeking to make it kind of a reverse, where the protected person through counsel would petition for ending a guardianship, and then the burden was on the guardian to prove that it continued to be necessary. That bill didn't move forward for whatever reason, so I know there was interest in that, but I don't think that this disturbs kind of that ecosystem.
Please follow up.
Thank you, Vice Chair. Okay, so that was it. Someone says, I want to get rid of that guardian. I don't like that person. I don't feel they're doing things in my best interest. They want to get rid of the guardian. Do they have to wait a full year until it's time that they're going to go back to their status conference or talk to somebody? I mean, you just said there was a bill last session, but it failed. It didn't go anywhere. So that's where I'm focused right there.
Thank you, Homa Sayar, for the record. I think the concern of the bill last session was that the Guardianship Commission hadn't been consulted and it maybe hadn't been fully thought out. You can go. part of the Guardianship Protected Persons Bill of Rights is that you can at any time have a hearing. This is not limited to like, oh, you get one in a year. You could come back every month if you wanted to. And there are often these continued hearings. So you have a right to ask the court to look at your case, to look at the circumstances, to change things. You can then have your attorney petition to end the guardianship. The way you end a guardianship is to prove that recovered capacity, right? So then if the guardian's blocking the person, you can't get a physician's certificate to say, oh, you're fine now, then the attorney has a way to do a motion and say, court, I really need to get this second opinion, or we need to work and be their advocate.
Vice Chair, I'm sorry. So I think that therein lies the problem. If you have a guardian, how do you then say, hey, I'm going to use some of my money to go hire a lawyer and go petition and get rid of that guardian? I think you can't do that, right?
Thank you for the question, Homosire. For the record, every attorney appointed for a protected person in every case is 100% free for the individual. They do not have to find them. They do not have to hire them. It is automatically appointed from a legal aid entity. And so then they're able to marshal resources. We've been able, I know when I worked for Health and Human Services, we were able to get coverage for like those additional examinations. So it was not a cost to the individual at all.
And the person who's under the guardianship can just make a phone call and say, hi, I have a guardian, but I don't like my guardian, I want to get rid of him? Or does the guardian somehow have input like, oh, no, you need to take your medication? I mean, that's the concern.
Thank you for the question, Homosire. For the record, that person absolutely can make that phone call. And like I said, it's a civil penalty. I believe it's $5,000 per violation if somebody's blocking that individual from exercising those rights. It's a long list of rights of communication, of access to the courts. So we make sure, or the system makes sure, that the guardian has to attest that they know about the Guardianship Protected Persons Bill of Rights. So again, a lot of these are procedural. And I will say, sometimes you can't legislate culture, right? Like, a lot of the things that you're seeing and hearing have to do with our own assumptions about aging, our own assumptions about disabilities. But I will say that sort of the courts, counsel, free legal counsel, the advocates, the individual, I think that we've been bolstering their strength in the face of sort of that allegation of exploitive guardians. And just by way of background, I was the attorney who handled about 47 cases related to April Parks when she fled the jurisdiction previously and was engaged in some serious exploitation. And in those cases, a lot of the safeguards had been ignored at the time, but we're light years away from that. Are there abuses in any court situation? Yes, but there are ways to sound the alarm. There are ways to get it looked at, and I've appeared in just about every county in guardianship. Our judiciary is amazing in this area. They are getting informed, they're getting educated, and they're understanding disabilities better and better to assist people.
Thank you, appreciate it. With that, I'd like to invite anybody else wishing to speak in the neutral position to please come forward. Seeing none, BPS, we have anybody wishing to join us over the phone in the neutral position for Senate Bill 346?
Thank you, Chair. The public lines are open and working, but there are no callers to provide neutral testimony at this time.
All right, perfect. Thank you. With that, Madam Chair, any closing remarks? Seeing no, understood. With that, we'll go ahead and close out the hearing on Senate Bill 346.
Thank you so much, Vice Chair Flores, for running such a wonderful hearing as always. That brings us to the last item on our agenda today, which is public comment. Anybody wishing to give public comment in person in Carson City or in person in Las Vegas is invited up to the front now. But I don't see anybody coming to the front of either room, so we will go to the phones, please, for public comment.
Thank you, Chair. If you would like to provide public comment today, please press *9 now to take your place in the queue. There are no callers wishing to provide public comment at this time.
All right, then that brings us to the end of our meeting. I do have a special announcement this afternoon. Tomorrow, there is going to be a very special event being held in 2200, which is the room next to the cafe, at noon. It is a panel put on by Return Strong. Mr. Macias from Return Strong presented the bill on medical debt relief with me, and I also know, having served as chair of this committee for the last few sessions, that everybody is always really impressed and really touched when we get to hear from people who were formerly incarcerated when they come to testify on bills. Tomorrow is an opportunity like that. Instead of testifying on a bill, a number of formerly incarcerated people are going to be sitting on a panel in room 2200 at 12 p.m. noon, and I would encourage everybody from the committee to attend. I will be there, and at a good breaking point at or near 1 p.m., I will make my way back down here to begin our meeting tomorrow at 1 o'clock. So I hope to see you all in room 2200 tomorrow at noon, and again at 1 o'clock here, and until then, we are adjourned.